Welcome to Different Like Me Culture with your host, Alyse November, a licensed clinical social worker for more than 21 years, who brings a brand new approach to learning by providing hands-on, interactive, web-based lessons that are easy to use and implement, and focus on some of the most important topics in today's society: bullying, dementia, special needs, relationship issues in 55-plus communities. These 4 topics are the focus of the Different Like Me Culture program. For more information, call 561-270-2280 and begin your pro-action approach towards these major challenges in our community. Call 561-270-2280 today and get started. Now, here's your host, Alyse November.
Hi, and welcome to Different Like Me Culture. I'm Alyse November, your host of the show. And we are looking to make the world a better place to live in. I am joined today by Michelle Hollister, who is an attorney specializing in elder law. She has earned her master's degree in business administration, and she is also a member of the elder law section of the Florida Bar. She serves as immediate past president of the National Guardianship Association. In addition, Michelle is an accredited attorney with the Veterans Administration. She has an elder law practice in Boca Raton with a focus on long-term care needs of her clients, as well as estate planning. Previously, she was appointed by Governor Jeb Bush as the executive director of the statewide Public Guardianship Office. And Michelle continued in this role for Governor Charlie Crist's administration. Michelle has participated on numerous state and local committees and work groups, including Governor Jeb Bush, that's a tongue twister, Governor Jeb Bush's Blue Ribbon Panel on the developmentally disabled, Governor Bush's work group on the guardianship and developmentally disabled, and the Florida Development of Children and Family Select Advisory Panel on Adult Protective Services. And more recently, Michelle provided testimony to the United States Senate Judiciary Committee subcommittees regarding pending legislation affecting elders in the United States. So I am so happy that you're here.
Thank you. It's nice to be here.
Yes. So today we're going to talk about legal issues regarding special needs, guardianship, the school system, and we'll just kind of go from there.
Okay.
So why don't we just talk a little bit about, why don't you just, in your words, kind of explain what you do in a nutshell and a little bit about your practice?
Sure. So my practice focuses on long-term care planning, and although the profession uses the term elder law, it really does affect not just elders, persons with disabilities, and quite frankly, just about anybody needs to sit down with somebody with my expertise. And the reason I say that is because we talk about planning in the context of what happens if we couldn't make decisions for ourselves. And that doesn't mean just you're aging or you were born with a disability. It could be a car accident. It could be an illness. There are many reasons why somebody may need the work and advice and counsel of what I do. So the term elder law is a little misleading.
Mm-hmm. It definitely is. And I know you're amazing at what you do. I learn so much every single time I talk to you. And every single time we talk about, even, when we talk about my own personal issues, and just, saying to me, hey, Alyse, do you have this? Do you and your husband have that? Do you have, different things in place? And I say, no. And then I say, well, I don't know if I could sleep at night because I keep thinking about it. And I know it's something we still actually have to finish. And I mean, just in terms of working with you on my own personal stuff, I learned so much that I just had no clue. And I'm a professional, and I think I'm fairly intelligent. But I think that the general population just doesn't know or understand about planning needs, or the other issue might be people avoid it. Because when you're talking about planning, you're talking about your potential death or illness, or, something's going to happen.
Right.
And people, I think, have difficulty facing that.
Without a doubt. People certainly don't want to think of their own mortality. Everybody wants to think they're just going to pass away in their sleep someday, and they certainly don't want to think about a car accident or any other or illness or a bigger tragedy. People just don't think about it. And then again, we also have people that struggle with decision making that don't have a diagnosis of cancer or Alzheimer's. They were just maybe born with a disability. And for instance, when we were talking about the school system. So it's a perfect example where somebody who maybe has a disability, we all hear about the numbers of children with autism, and they're on the spectrum, and the parents, their only contact is the school system for information. And maybe, if they're lucky, somebody in the school tells a parent, oh, your child's going to turn 18. You don't automatically get to make decisions anymore. And then they throw out the word guardianship sometimes, and a parent gets, overwhelmed. They start to research it, and they should get overwhelmed. Guardianship is a big deal. It's not something to take lightly. It's a court process. It's expensive. Many lawyers are involved, and a lot happens. And fundamentally, it's the removal of somebody's rights. And so it's a very big deal.
Scary. It's scary to think about because it kind of feels permanent. And I know guardianship isn't permanent.
That's correct.
But it feels scary. It's almost like you feel like you're being put in a cage with no rights, and you have to say, okay, may I, can I? I think it's intimidating for a lot of people to think about.
And it should be. It's because of its importance. The removal of somebody's rights. If somebody one day sent me a piece of paper that said, my license has been taken away, I can't vote anymore, I can't work. What would you do? But that's what guardianship.
Run to my cover saying help.
Exactly.
What do you do?
And guardianship can be like that. Now, that said, there are times where there may be a need for it, but it's not something to take lightly. And so just because a person may have been born with a developmental disability doesn't necessarily mean that a parent has to run to guardianship in preparation of a child's 18th birthday. There are alternatives. And for those of us that practice in this area, we want families to seek those alternatives if appropriate. We believe in people maintaining their rights. That's, one of the benefits of living where we live. And you can always go to guardianship if you have to, but there's no reason to start there. And I think that would be one of the key points that I would want your listeners to know, that if they do go to speak to somebody and do some planning, and that person right away uses the G word, guardianship, without talking about lesser restrictive alternatives, well, they may want to seek, some other advice, because there are things like durable powers of attorney and healthcare advance directives, which may be very appropriate. Again, not to say that guardianship won't someday be necessary, but you don't have to start out there. Mm-hmm. And there's a big push, there was a World Congress on Guardianship in May in D.C., and it brought together people from all over the world. And I was a presenter at that conference, so I had the ability to attend many of the sessions. And what was amazing to me is I think in this country tend to have an ignorance that what we do is the best, and that we're so far ahead of other countries. And we're not when it comes to surrogate decision making. There are other countries that treat seniors as well as people with developmental disabilities much better than we do. And our federal government is starting to realize this as well. And there is going to be, I believe, a movement in the states to change our guardianship laws. And Florida is a leader in guardianship laws. I helped to write many of the laws we have today. But I think we're going to see a change where we're going to start to focus on person-centered planning and supported decision-making. And I think that will be a good thing.
So how does that differ from what we're doing. And before you answer that question, I just want to let our listeners know, if anybody has any questions for Michelle, you could call us at 888-565-1470. 888-565-1470. Okay, so now back to the question.
So how is supported decision-making, person-centered planning different?
Different from what we're currently doing. What is it? What does it look like? What does it entail?
It looks very different because it acknowledges that that everybody is a person and has their own unique abilities. It's not one size fits all, and that this person, this individual, may be able to live quite well with supports, with people helping them to get to a decision that's not necessarily the court system or judges or attorneys, but it's by the experts that are within their circle of support.
So, like, if I am a therapist of the client, of the patient, or the person that we're talking about, I might be considered, if I have been given permission to be able to talk about helping making decisions. Is that like people who are involved with the person and know the person? It would be
people that would be involved. I don't know enough about your professional standards to know if it would be appropriate for you to then help a client with legal decision making. I quite frankly don't know, but it would be, the parents, the case workers, all of the players, all of the people that look, we all, before we make big decisions, talk to our friends, our parents, our spouse, our best friend, our siblings.
Our therapists.
We all have
right.
circles of support.
Right.
So why can't we acknowledge these circles of support for people with a disability? And so that's what I think we're going to start seeing the trend, where we're going to see a recognition in law that we should be doing this.
And why aren't we doing it now? Or just having what's happening now that why wouldn't we use those types of supports? And I guess the question is what are we doing now that differs so much?
The reality is, informally, we are all over this country utilizing supported decision making. There are many, many people that never are even told that they can no longer make decisions for their child, and they're doing it. And the banks or the doctors or whomever, for whatever reason, it's happening. But that's not what the law provides. But we do see it, and we do see it quite successfully until a family hits a roadblock. And until the laws change, they're going to continue to hit those roadblocks.
So a roadblock would be two family members disagreeing?
That would be a roadblock.
Would that be a roadblock?
A bank saying, I know you're their mom, I know you're all they have, but you know what? You really don't have any legal authority. Mm-hmm. And let's not forget that there's the opposite side of the spectrum of what we're discussing. There are going to be people that absolutely need guardianship, that need the protection, because regardless, there are predators. You can't open the newspaper these days and not see a story about a caregiver or somebody taking advantage of a senior. So there are going to be times where guardianship or court involvement is very appropriate, but that doesn't mean we should turn a blind eye to the times where it's not.
Mm-hmm. Okay. So very interesting information, and I kind of like where they're going, and I hope it happens soon for the sake of, I guess, the population that we help and take care of, because that kind of it makes sense. It makes perfect sense. It really does. So, okay, so let's talk a little bit more. We were talking a little bit initially about special needs and why somebody would need to have, I guess, either guardianship or some type of control. Because, like, I think about it with my son, and you and I were talking a little bit prior to the show, and we were talking about, well, medically, do I need it medically for him if he's 18 years old? So is that something that's important to have as a parent?
So what's important for people to know, first of all, is when anybody turns 18 in this country, they're considered an adult. Okay, unless they've been emancipated prior. At their 18th birthday, they're going to be considered an adult. So when it comes to financial decision making and things of that nature, the law is pretty clear that you're going to need either guardianship or their power of attorney. Now, for healthcare decision making, at least in the state of Florida, our statutes provide a mechanism for people who do not have what we would call a healthcare advance directive, which would be the health equivalent of a power of attorney. And so Florida statutes have a hierarchy of who can help somebody if there is no healthcare power of attorney. And that's wonderful. But again, the person who didn't put their wishes in writing are then at the mercy of who's ever named in the hierarchy of the statute. So, usually it's the first would be a spouse, and then a parent, and then a sibling. So let's say your son, okay? Your son is 18 and something happens medically, and for whatever reason, he's not able to communicate to the physicians. Well, under the law, you would be able to assist him without the document. But what if you and your son have a fundamental disagreement on issues? For instance, maybe you hold different religious beliefs and he needs a blood transfusion or something of that nature. And he doesn't want it and you want him to have it. Well, without him putting his wishes in writing, that's an issue. So from a healthcare decision standpoint, it's really of importance to the individual that we're discussing. That's the focus of needing the assistance that should put their wishes in writing. The law is going to provide the family a mechanism to act in those instances.
Is that at any age a family can act? At any age? Like, let's say, God forbid, something happened to me now and I don't have advance directives. My husband has first dibs on what he says happens to me.
That's exactly right. And the most famous example we have in our state is Terry Schiavo. So Terry Schiavo was in her 30s, and she lost consciousness, and she had a husband, and she had parents. And they disagreed, and nobody knew what Terry wanted because it wasn't in writing. And that's really probably the most well-known example.
Mm-hmm. Mm-hmm. So I think what you're saying is, if it ain't written, same thing when I used to work in a hospital. If you didn't write it, you didn't do it. So you got to get
That's right.
You have to get your needs and wishes known and do it legally. And now, are there any documents that people could do that can be done without an attorney? I mean, I know that Office Depot sells lots of different forms and things like that. What are those?
Yeah, that's an excellent question. Technically, under the law, if the documents are executed in accordance with what the laws say, the two witnesses and the notary and all that good stuff, then technically it should be valid. The problem is when you don't utilize the expertise of an attorney, you may not have addressed everything that you need to. For example, in the state of Florida, our laws say that your power of attorney needs to spell out every single thing you want your agent to do. And if you didn't put it in that document, the law assumes you didn't mean to delegate it. So if you're using an off-the-shelf document that's very general and says, for example, can create all trusts or can do whatever I can do, you could run into a problem. The best example is with Medicaid planning. There are certain legal documents that need to be created generally for Medicaid planning. And if the power of attorney doesn't spell out that the agent can sign these certain documents, you may lose out on tens of thousands of dollars worth of benefits.
Wow.
Yeah, so it's worth spending a few $100s to get these documents done right than gambling with some off-the-shelf documents.
Mm-hmm. And that's another thing, not that we want to quote fees, but I think sometimes people are afraid to go to an attorney because you think oh yeah, I'm going to be charged $350 an hour or what have you. Mm-hmm. And I mean, I think, to kind of take away that myth that it's going to cost just tens of thousands of dollars to get something like this done, because it doesn't. Right? Am I right?
It's just like any service. There's all a wide variety of price ranges, and the best thing to do is to talk to friends that maybe have done these documents and get a recommendation. Look on the Florida Bar website, make sure there's no disciplinary complaints or anything of that nature. See where their memberships are. But you're going to find, just like with mechanics and plumber and anything else, you're going to find a wide variety of prices, and you go with your comfort level. But it's not out of the ballpark for the majority of people. It can be quite affordable. And if you make one phone call and you feel that it's not right, you make another phone call.
Mm-hmm. And something we talked about a while back, because I know a lot of people move from up north to Florida.
Right.
And documents, because I know when I work with my patients, they ask me, they say, oh, yeah, my attorney up in New York 20 years ago did this document. And, oh, yeah. And I say, well, you should probably at least have a consult with an attorney to make sure it's still good, because you tell me why, best.
For generally, if a document was executed in accordance with the laws of the state it was signed in, then technically it should be valid in any state. That's why in our Constitution we all learn in grade school about the full faith and credit, clause of our Constitution. But the reality is, if let's say state A only requires one witness on a document, and here in Florida we require two. Well, if in a crisis, somebody in the state of Florida is reading the document and only sees the one witness and doesn't know any better, not because they're malicious, just because they just don't know, then says they're not going to honor the document. If you're in a crisis, you don't want to have to start fighting with hospitals or banks or wherever over something like that. And so I always recommend especially to my snowbird clients, have a set for both states, but especially for people who, if they're here permanently, absolutely have a lawyer here. Sit down, have a consultation, start a relationship here, have a go-to person. And chances are, at some point documents need to be updated, whether you stayed in Florida your whole life or not. So, in your example, you had said they did them 20 years ago. Well, it's probably time to update.
Well, the laws have changed too, right? Yes? No? Things have
do,
changed.
but you don't necessarily have to update because of that. But what people don't think about is they did it 20 years ago when maybe they had their best friend Joe in the document, and Joe's not their best friend anymore, or Joe has passed. So people tend to think, oh, yes, I did it. And they don't really remember the details of what they did. And because of that, it could be not as effective as it could be if it were current.
Right. And also second marriages, if you've gotten married again.
That's right. Or divorced.
Or what have you, to make sure that everything is up to date, and that who you want to leave your money to, if we're talking about a will, is the person that you want to leave it to, or sometimes, children become estranged or what have you. So just to update the documents. And I know through working with you, there's so many different options that people can choose from at this point, as far as, who to put on what and how to deal with family members that might be more difficult, or issues that come up. And I know sometimes it's really hard to make those decisions. I know I've sat in therapy with many patients who just agonize over making decisions on legal documents, and the best thing I tell them is, you're not going to be here to worry about it. So, do what you think is best. Do what they're worried sometimes about, the repercussion and how family members will feel. But you always have to do what's
true.
Yeah.
In terms of a will or trust, things that will affect distribution when you're gone, but they still struggle with those issues in terms of powers of attorney and healthcare, because those are what's important when you're alive. And it absolutely, I've had countless meetings that people can struggle with those decisions, and usually we're able to come up with something workable, and that gives the client peace of mind. But you're absolutely right. It can be difficult, and that sometimes is why people avoid doing it. But not doing it, and this is key, not doing it and putting your head in the sand. If you should become incapacitated and somebody needs to make, especially a financial decision, chances are you're going to end up in guardianship. And that is, like I said earlier, expensive, time-consuming, and really intrusive.
Mm-hmm. Yeah. It's a bit of a crazy process. So let me ask you a question. So what's your biggest professional pet peeve? What would you say your biggest professional pet peeve is?
Oh my goodness. I think it's when people, don't are somewhat closed off to what we're saying, the importance, not appreciating the significance of what could happen to them. We all want to believe that everything's going to be perfect in our lives. We're going to live these ideal lives, and keeping their head in the sand. Mm-hmm. No matter how you can give example after example after example, and sometimes they just don't get it. And you could have helped, but
and then you find out later on, where something happened, and they come to you in crisis, and sometimes I'm guessing there's nothing you could do.
But usually, it depends on the situation. We always try to salvage it, but it's always better to plan. People do not make good choices in crisis.
Plan ahead is really what you're saying.
Yep.
So I'd like to thank you for being here as my guest.
My
it's
pleasure.
just been
Thank
an
you.
absolute pleasure speaking with you. I always learn new information. And if somebody wants to reach you, why don't we give them your contact information?
Sure. So my phone number is area code 561-401-0743.
One more time.
561-401-0743. Or via email at michelle@michellehollister.com.
Thank you. Thank you so much for being here.
My pleasure.
Appreciate it.
Thank you for tuning into Different Like Me Culture with Alyse November. Join us every Monday at 6 p.m. Call 561-270-2280 for more information. And tune in again next week for more Different Like Me Culture. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.